Marquez v. Cumlic. Facts: it is averred that at the time respondent Rodriguez filed his certificate of candidacy, a criminal charge against him for 10 counts of insurance fraud or grand theft of personal property was still pending before the Municipal Court of Los Angeles, USA. A warrant issued by said court for his arrest, it is claimed, has yet to be served on private respondent on account of his alleged flight from that country. Before the May 1992 elections, a petition for cancellation of respondent's certificate of candidacy on the ground of the candidate's disqualification was filed by petitioner, but Cumlic dismissed the petition. Private respondent was proclaimed governor-elect of Quezon. Petitioner instituted quo warranto proceedings against private respondent before the Cumlic, but the latter dismissed the petition. Issue: whether private respondent, who at the time of the filing of his certificate of candidacy is said to be facing a criminal charge before a foreign court and evading a warrant of arrest, comes within the term fugitive from justice. Held, the Supreme Court ruled that Article 73 of the Rules and Regulations implementing the Local Government Code of 1991 provides. Article 73. Disqualifications: the following persons shall be disqualified from running for any elective local position. XXXX fugitives from justice in criminal or non-political cases here or abroad. Fugitive from justice refers to a person who has been convicted by final judgment. It is clear from this provision that fugitives from justice refer only to persons who has been convicted by final judgment. However, Cumlic did not make any definite finding on whether or not private respondent is a fugitive from justice when it outrightly denied the petition for quo warranto. The court opted to remand the case to Cumlic to resolve and proceed with the case. The Oversight Committee evidently entertained serious apprehensions on the possible constitutional infirmity of Section 40 of RA 7160 if the disqualification therein meant were to be so taken as to embrace those who merely were facing criminal charges. A similar concern was expressed by Senator R.A.V. Sigwisig, who, during the bicameral conference committee of the Senate and the House of Representatives, made this reservation. De IPA refine lang naden yung language, especially yung, the scope of fugitive. Me dio bothered ako dun, a. The Oversight Committee finally came out with Article 73 of the Rules and Regulations implementing the Local Government Code of 1991. It provided Art. 73 disqualifications. The following persons shall be disqualified from running for any elective local position. Fugitives from justice in criminal or non-political cases here or abroad. Fugitive from justice refers to a person who has been convicted by final judgment. Private respondent reminds us that the construction placed upon law by the officials in charge of its enforcement deserves great and considerable weight. The court certainly agrees, however, when there clearly is no obscurity and ambiguity in an enabling law, it must merely be made to apply as it is so written. An administrative rule or regulation can neither expand nor constrict the law but must remain congruent to it. The court believes and thus holds, albeit with some personal reservations of the ponent, that Article 73 of the Rules and Regulations implementing the Local Government Code of 1991, to the extent that it confines the term fugitive from justice to refer only to a person who has been convicted by final judgment, is an inordinate and undue circumscription of the law. Unfortunately, the Cumlic did not make any definite finding on whether or not, in fact, private respondent is a fugitive from justice, as such term must be interpreted and applied in the light of the court's opinion. The omission is understandable since the Cumlic dismissed outrightly the petition for quo warranto on the basis instead of Rule 73 of the Rules and Regulations promulgated by the Oversight Committee. The court itself, not being a trier of facts, is thus constrained to remand the case to the Cumlic for a determination of this unresolved factual matter. Davide, concurring. The term fugitive from justice refers not only to those who flee after conviction to avoid punishment but also to those who, after being charged, flee to avoid prosecution. In his ponencia, Mr. Justice Jose C. Vidig finds the definition given to it by the Oversight Committee, i.e. a person who has been convicted by final judgment, as appearing in Article 73 of the Rules and Regulations implementing the Local Government Code of 1991, as inordinate and as undue circumscription of the law. I agree. But this is only one side of the coin. I further submit that it also unreasonably expands the scope of the disqualification in the 1991 Local Government Code because it disqualifies all those who have been convicted by final judgment, regardless of the extent of the penalty imposed and of whether they have served or are serving their sentences or have evaded service of sentence by jumping bail or leaving for another country. The definition thus disregards the true and accepted meaning of the word fugitive. This new definition is unwarranted, for nothing in the legislative debates has been shown to sustain it, and the clear language of the law leaves no room for a re-examination of the meaning of the term. I do not share the doubt of Mr. Justice Vidig on the constitutionality of the disqualification based on the presumption of innocence clause of the Bill of Rights. There are certain fundamental considerations which do not support the applications of the presumption. Firstly, Section 1. Article V of the Constitution recognizes the authority of Congress to determine who are disqualified from exercising the right of suffrage. Since the minimum requirement of a candidate for a public office is that he must be a qualified voter, it logically follows that Congress has the plenary power to determine who are disqualified to seek election for a public office. Secondly, a public office is a public trust. Thirdly, the disqualification in question does not, in reality, involve the issue of presumption of innocence. Elsewise stated, one is not disqualified because he is presumed guilty by the filing of an information or criminal complaint against him. He is disqualified because he is a fugitive from justice, i.e., he was not brought within the jurisdiction of the court because he had successfully evaded arrest, or if he was brought within the jurisdiction of the court and was tried and convicted. He has successfully evaded service of sentence because he had jumped bail or escaped. The disqualification then is based on his flight from justice. In the face of the settled doctrine that flight is an indication of guilt, it may even be truly said that it is not the challenged disqualifying provision which overcomes the presumption of innocence, but rather the disqualified person himself who has proven his guilt. Rodriguez v. Cumlick. Facts: the petitioner Eduardo T. Rodriguez was a candidate for governor in the province of Quezon in the May 8, 1995 elections. His rival candidate for the said position was Bienvenido O. Marquez, Jr. Herein Private Respondent filed a petition for disqualification before the Cumlick based principally on the allegation that Rodriguez is a fugitive from justice. Private Respondent revealed that a charge for fraudulent insurance claims, grand theft, and attempted grand theft of personal property is pending against the petitioner before the Los Angeles Municipal Court. Rodriguez is therefore a fugitive from justice, which is a ground for his disqualification/ineligibility under Section 40 of the Local Government Code according to Marquez. Rodriguez, however, submitted a certification from the Commission of Immigration showing that Rodriguez left the U.S. on June 25, 1985, roughly 5 months prior to the institution of the criminal complaint filed against him before the Los Angeles court. The Cumlick complied therewith by filing before the court, on December 26, 1995, a report entitled Evidence of the Parties and Commission's Evaluation, wherein the Cumlick, after calibrating the parties' evidence, declared that Rodriguez is not a fugitive from justice as defined in the main opinion in the Marquez decision, thus making a 180-degree turnaround from its finding in the consolidated resolution. In arriving at this new conclusion, the Cumlick opined that intent to evade is a material element of the Marquez decision definition. Such intent to evade is absent in Rodriguez's case because evidence has established that Rodriguez arrived in the Philippines long before the criminal charge was instituted in the Los Angeles court. But the Cumlick report did not end there. The poll body expressed what it describes as its persistent discomfort on whether it read and applied correctly the Marquez decision definition of fugitive from justice. Issue: whether or not Rodriguez is a fugitive from justice. Held no. The Supreme Court reiterated that a fugitive from justice includes not only those who flee after conviction to avoid punishment but likewise who, being charged, flee to avoid prosecution. The definition thus indicates that the intent to evade is the compelling factor that animates one's flight from a particular jurisdiction. And obviously, there can only be an intent to evade prosecution or punishment when there is knowledge by the fleeing subject of an already instituted indictment or of a promulgated judgment of conviction. The definition thus indicates that the intent to evade is the compelling factor that animates one's flight from a particular jurisdiction. And obviously, there can only be an intent to evade prosecution or punishment when there is knowledge by the fleeing subject of an already instituted indictment, or of a promulgated judgment of conviction. Rodriguez's case just cannot fit in this concept. There is no dispute that his arrival in the Philippines from the U.S. on June 25, 1985, as per certifications issued by the Bureau of Immigrations dated April 27, 3 and June 26 of 1995, preceded the filing of the felony complaint in the Los Angeles court on November 12, 1985 and of the issuance on even date of the arrest warrant by the same foreign court, by almost 5 months. It was clearly impossible for Rodriguez to have known about such felony complaint and arrest warrant at the time he left the U.S., as there was in fact no complaint and arrest warrant, much less conviction to speak of yet at such time. What prosecution or punishment then was Rodriguez deliberately running away from with his departure from the U.S.? The very essence of being a fugitive from justice, under the Marquez decision definition, is just nowhere to be found in the circumstances of Rodriguez. The circumstantial fact that it was 17 days after Rodriguez's departure that charges against him were filed cannot overturn the presumption of good faith in his favor. The same suggests nothing more than the sequence of events which transpired. A subjective fact as that of petitioner's purpose cannot be inferred from the objective data at hand in the absence of further proof to substantiate such claim. In fact, the evidence of Rodriguez sufficiently proves that his compulsion to return to the Philippines was due to his desire to join and participate vigorously in the political campaigns against former President Marcos. For indeed, not long after petitioner's arrival in the country, the upheaval wrought by the political forces and the avalanche of events which occurred resulted in one of the more colorful events in the Philippine history. And being a figure in these developments, Rodriguez began serving his home province as OIC board member of the Sangguniang Panlalawigan ng Quezon in 1986. Then, he was elected governor in 1988 and continues to be involved in politics in the same capacity as re-elected governor in 1992 and the disputed re-election in 1995. Altogether, these landmark dates hem in for petitioner a period of relentless, intensive, and extensive activity of varied political campaigns, first against the Marcos government, then for the governorship. And serving the people of Quezon province as such, the position entails absolute dedication of one's time to the demands of the office. Having established petitioner's lack of knowledge of the charges to be filed against him at the time he left the United States, it becomes immaterial under such construction to determine the exact time when he was made aware thereof. While the law, as interpreted by the Supreme Court, does not countenance flight from justice in the instance that a person flees the jurisdiction of another state after charges against him or a warrant for his arrest was issued, or even in view of the imminent filing and issuance of the same, petitioner's plight is altogether a different situation. When, in good faith, a person leaves the territory of a state not his own, homeward bound, and learns subsequently of charges filed against him while in the relative peace and service of his own country, the fact that he does not subject himself to the jurisdiction of the former state does not qualify him outright as a fugitive from justice. However, Marquez and the Kumlik seem to urge the court to redefine fugitive from justice. They espouse the broader concept of the term enculled from foreign authority cited in the Marquez decision itself, i.e., that one becomes a fugitive from justice by the mere fact that he leaves the jurisdiction where a charge is pending against him, regardless of whether or not the charge has already been filed at the time of his flight. Suffice it to say that the law of the case doctrine forbids the court to craft an expanded redefinition of fugitive from justice and proceed therefrom in resolving the instant petition. The various definitions of that doctrine have been laid down in People v. Pinuila. To elaborate, the same parties and issue are involved in the Marquez decision and the instant petition. The Marquez decision was an appeal from EPC No. 92-28. The instant petition is also an appeal from EPC No. 92-28, although the Kumlik resolved the latter jointly with SPA No. 95-089, Marquez. Petition for the disqualification of Rodriguez. Therefore, what was irrevocably established as the controlling legal rule in the Marquez decision must govern the instant petition. And we specifically refer to the concept of fugitive from justice as defined in the main opinion in the Marquez decision, which highlights the significance of an intent to evade, but which Marquez and the Kumlik, with their proposed expanded definition, seem to trivialize. Besides, to redefine fugitive from justice would only foment instability in our jurisprudence when hardly has the ink dried in the Marquez decision. Torres, Jr. Petitioner returned to the Philippines from the United States on June 25, 1985, while the criminal complaint against him for fraudulent insurance claims, grand theft and attempted grand theft of personal property was filed almost 5 months later, or on November 12, 1985. Verily, it cannot be said that he fled to avoid prosecution, for at the time he left the United States, there was yet no case or prosecution to avoid. That petitioner did not know of the imminent filing of charges against him, and that he did not flee to avoid prosecution are bolstered by the facts that, 1. He returned to the United States twice, on August 14 and October 7 of the same year, but arrived in the Philippines on October 26 likewise in the same year. 2. He left his wife in the United States, and 3. His wife was later on arrested for the same. Charges. Had petitioner been aware of the imminent filing of charges against him, he would never have returned to the United States, and he would not have left his wife in there. Petitioner is a citizen of this country. Why should he not come home? Coming home to the Philippines was the most natural act of the petitioner, who happens to maintain his residence in the country. The fact that he remains here even after he was formally accused cannot be construed as an indication of an intent to flee, there being no compelling reason for him to go to the United States and face his accusers. On the contrary, it is his official duty, as an incumbent governor of Quezon, to remain in the country and perform his duties as the duly elected public official. Fugitive from justice must be given a meaning in the instant case having regard to the circumstances and the time it is used. Philosophers and jurists have tried unsuccessfully at an exact definition of such an abstruse term as justice. Unfortunately, whether in the metaphysical sense or otherwise, the question of justice is still unanswered as it ever was, albeit characterized by secular skepticism. If the question is asked, what standard of justice should we enforce? The American sense of justice or the Philippine sense of justice? Undoubtedly, the forum in which it is raised should be controlling. By way only of hypothesis, if an American flees to escape from Philippine laws to the United States, may we enforce in the United States our standard of justice based on Philippine laws? I am tempted to ask these questions considering our zealousness to solve legal problems in the light of laws obtaining in the United States. At any rate, an accused charged with a crime in the Philippines cannot be a candidate and at the same time flee from prosecution. Once he goes campaigning, his opponent would have him arrested. For this and the reasons above discussed, the provision on disqualification of fugitive from justice, being unnecessary and serving only to undermine one's constitutional right to equal access to opportunities for public service, should even be scantily considered. Finally, petitioner appears to have garnered 285,202 votes. According to the election results, petitioner won over private respondent by a majority of 140,000 votes more or less. As it is, to disqualify petitioner on the shaky ground of being a fugitive from justice would amount to disenfranchising the electorate in whom sovereignty resides.